Maybe not. Docket is this morning. He didn't show up.
All right, is that better, Deputy McLeish?
Sounds good so far.
Well, it's looking better on your end, mine, so let's give it a shot.
Thank you. This Abraham kind of plugged it, wasn't plugged in, so maybe that had something to do with it.
Okay. Mr. Schmidt, are you ready on, sir?
Jamie Nash.
All right, Jamie Nash. CR 22-366. And what are we doing today on Ms. Nash?
Say again.
What are we doing today on Ms. Nash?
On a plea of true, state's recommending to the court that her guilt be adjudicated. That she be sentenced to 4 years TDCJ, that be suspended for a period of 3 years, placed on ISP, or to pay the balance of her financial obligations.
Just because we're going from probation to probation, that needs some justification as to why we keep her on probation.
Who are you seeking justification from, Judge?
Whoever wants to speak up, I'm trying to find out. So we moved probation to probation. I want some justification for the agreement on why we're taking somebody who's failing on probation and putting them back on.
Judge, I would say that Ms. Nash has a serious addiction problem. She's aware of it. She struggled with controlled substances. She did not do very well the last time because of controlled substances. She's been sitting here for quite some time. She's clean. She's ready to get her life together. I think that the goal and the hope is to give somebody who finds themselves in the position of a narcotics related crime, use and possession specifically, to be successful members of society. And we should put the effort in, and if she's willing to make it, she should get that opportunity rather than sending her to the pen where there is no purpose behind that. I think that she's ready to hopefully avail herself of the resources available through probation to make sure that she doesn't continue to fall into these patterns of addictive behaviors.
The state's motion appears to me that she was never on probation. She did report the very next month. And
once again, Judge, I would reiterate my statement. We have individuals who get out of custody still heavily addicted to drugs such as methamphetamine, and they don't make good choices. There's no doubt about it. And Ms. Nash is unfortunately one of those people. I'd like to believe that she's been in custody long enough this time where she understands that her mind is at least as clear as it can be to put her in the right place so that she walks out of here. She will be on track to hopefully never violate again.
so Ms. Nash doesn't need rehab, safety. She's going to be straight and narrow now, just coming out of county jail.
I think so. She's going to be on intensive supervision, Judge. And she'll either make it or she won't. I guess that's the truth with everybody who's placed on probation. They have to make their own choices. And And that addiction is keeping her in a bind. I'd like to believe, and of course, I'm sure she'd say herself, she's ready to be done with this.
That's what I was hoping the first time I put her on probation. I just don't know that I got that much faith in her at this point. I've seen very few people battle a drug addiction on their own just by going to jail and serving jail time and getting out. Let me think about that. Think about that. Nash, have a seat and I'll call you back in. Do you have anyone else you're ready on? Who do you have, Mr. Smith?
Matthew Hogg.
Matthew Tom Hogg, CR 21-125. Go ahead. What are we doing on Mr. Hogg today?
Judge, reached an agreement with the state that upon plea of true, Mr. Hogg's community supervision be revoked and be sentenced to 3 years. Texas Department of Criminal Justice Institution Division, order to pay the balance of his financial obligations. He has 164 days credit towards that.
Okay. All right, Mr. Hogg, raise your right hand on the place of Rose. Mr. Hogg, raise your right hand. Sir, do you swear that the testimony you give to the court today will be, Mr. Hogg? We're not gonna have any antics today. I'm not gonna put up with it. I don't have patience for you today. Do you understand what I'm telling you?
Yeah.
Raise your right hand. Look at me. Raise your right hand. Just listen. Do you swear the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, put your hand down and really think about what you're about to say the next time you open your mouth. You understand?
Yes.
I'm telling you, I don't have, hang on, Mr. Schmidt. I got it, Mr. Hogg, I'm well aware of you, your antics. They have followed you from Henderson County all the way over here to this jail. You're very well known in this courthouse. If you think that you're going to come in here and play around, you're sorely mistaken. You have an opportunity today to resolve your case. You're going to be the one that decides whether you resolve it today or not. You can sit here like a man and you can be accountable for your actions and you can accept it like an adult, or you can sit there and play around like a child. And I'll have the state put on their evidence and I'll decide how long you go to prison. I want you to stop and think about that for just a second. And you talk to Mr. Schmidt. Whatever Mr. Schmidt tells you, you better listen to him because he knows. Understand? Go ahead, Mr. Schmidt.
I apologize, Your Honor, but maybe I thought I had the wrong hand up, but this is the right hand. Your Honor.
Have a seat, Mr. Hogg. I'll call you back up in a second. If anyone else is ready, that's really ready.
Yeah.
Well, we don't have any. Mr. Manning is working his funds right now.
Abraham said that she thought there were some resets earlier.
We had the one reset, but you already took care of that with Mr. Stevens.
Okay.
So the only ones that we have left are both Mr. Schmidt's and Mr. Manning's clients, and both of those counselors are working with their people right now, sir.
Okay, let's give them time.
Thank you.
Ms. Curry, Mr. Patton. Roll call. All right, this is cause number CR 22-390, State of Texas versus J. Warren Finney. We that were set here today on a motion to suppress that, correct, Mr. Price? Do I have any agreements regarding the motion?
Your Honor, we'll agree that, well, council drafted a very fine motion that is very specifically tailored to what his complaint is, Judge, and we will agree that the action he is complaining of was done without a warrant.
All right.
I believe your comments earlier that, there's since the video, the entire video is watching all
Yes.
today for appellate purposes. Interaction, with this officer. This officer.
We'll call the officer that was involved, Your Honor, prove up the video, and then just submit the video for the court to review at a different time.
Okay. And Mr. Patton, you need kind of opening statement or anything, or any motion? No, Mr. Gregor?
No.
Okay, ready to proceed, Mr. Gregor?
Thank you, Your Honor. Brandon Whitus.
Officer Watts. I placed you under oath earlier for the purposes of this case. I'm going to do it again. Okay, raise your right hand, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So you remember my admonitions earlier from today? Yes, sir. Single. I'll take this one second. There's no point. That's. Like. There's a top. Every on the left. That's on. Sorry about that, Mr. Gregor, but.
Thank you. Good afternoon, sir. Would you state your name for our records, please?
Brandon Wattis,
Mr. Whitus, how are you employed, sir?
Canton Police Department,
And is that a full-time or part-time position?
part-time.
And do you have another full-time occupation?
Yes, ma'am.
And how long have you been working for Canton Police Department in any capacity?
I think it's in between 11 and 12 years.
During all of that time, have your duties been as a patrol officer for the city of Canton?
Yes, ma'am.
So when you are on patrol, what are your primary responsibilities?
Proactive traffic stops, respond to calls.
Do you recall, sir, whether you were on patrol the night of March 17th of 2022?
Yes, ma'am.
And do you normally, when you work for Canton, do you normally work nights?
Normally I do.
So on that evening, I'd like to direct your attention to 2328. I guess that's about 11:28 at night. Is that right?
Yes, ma'am.
Were you on patrol on the interstate at that time?
Yes, ma'am.
And can you tell me whether or not you noticed or saw a car that drew your attention near FM 1255 and Highway 19?
I did.
And tell us what happened that drew your attention to that car.
I seen the vehicle go to exit in front of me where I was exiting, and then it looked like it was going to swerve back to get on interstate, and then it corrected and stayed back on. the exit ramp.
So, you were driving your patrol vehicle,
Yes, ma'am.
and as you were driving, was it your intention to exit there?
Yes, ma'am.
And did you believe that vehicle was also exiting in front of you?
I didn't know if the vehicle was exiting, intending to exit, and then seen I was exiting also, and then changed their mind and then changed it back again, or I really didn't know what was going on.
So once you saw that action, did you have some suspicion?
Yes, ma'am.
And what were you suspicious of at that point in time?
That time of night, it could have been somebody intoxicated or somebody extremely tired.
Whether it was intoxication, tired, did you feel like the driver at that point was safe to be on the highway?
At the time I stopped the vehicle,
Yes.
I think the driver of the vehicle needed to be checked out to make sure.
So would it be fair to say that you had a reasonable suspicion that the driver needed to be checked out?
Yes, ma'am.
And so once you saw that, your suspicions were raised, what did you do?
I activated my lights and stopped the vehicle.
And is your patrol car equipped with a camera device, recording device?
It is
And what activates that camera?
activating the emergency lights, or we can manually activate it.
So if it's not already activated for some reason, when you flip on the red and blues, does the camera start?
It does.
So in this particular case, sir, did you switch on those red and blues before or after you saw the action of the driver that drew your attention?
Best I recall, it was after.
Did the driver respond to the emergency lights?
She did.
And what did she do?
She went up to the stop sign at FM 1255, and then I believe she crossed over 1255 and came to a stop.
Still on the service road?
Yes, ma'am.
And when the vehicle, do you recall what kind of vehicle it was, sir?
I do not. It was I know it was a small passenger car.
If I told you that your report said a gold Honda Accord, would that seem correct?
Yes, ma'am.
And when the Honda Accord stopped, did you approach the vehicle?
I did.
And did it stop on the right shoulder or the left shoulder?
I believe we were on the right, on the south side.
So was the passenger door away from the roadway, driver's door towards the roadway?
Correct.
And which side did you approach, driver or passenger?
Due to being on the ramp, on the service road, I went to the driver's side.
And when you went to the driver's side, what did you find?
Female driver.
Did you go through a normal traffic stop interaction with her?
I did.
And do you have kind of a normal set of questions that you start out with?
It depends on what I observe, but for the most part, yes, it's pretty standard.
And when you went through those questions with her, what did you find?
I'd have to refer to my report, but best I recall, she kept saying she had to go to the bathroom. She had started her period. She didn't have a driver's license. So I asked her to step out so I could obtain that information.
So is it routine for you to ask for a driver's license?
Yes, ma'am.
And did she have a driver's license that night?
I don't believe so. I believe I had to write down her name and date of birth.
Did you ask her to step out of the vehicle?
I did.
And what did you observe about her condition when she stepped out of the vehicle?
I could tell she was steady on her feet, and I didn't smell any alcohol, but she did tell me that she was extremely tired.
Did you tell her the reason for the stop?
I'm sure I did. I don't.
And did she have an excuse or a response with regard to that?
I don't recall.
Your Honor, may I approach the witness?
Yes, ma'am.
Officer Whitish, did you prepare a report?
Yes, ma'am.
And if I showed you a copy of that report, would you be able to recognize it?
Yes, ma'am.
If you've had it to glance through, would it refresh your memory on some of the finer details of this?
Yes, ma'am.
You can read through that, sir, and see if that refreshes your memory.
Okay.
Okay. So did she have an explanation or an excuse as to this, the swerving action that had first attracted your attention?
She said she was extremely tired.
Did her eyes, did you notice anything about her eyes?
Yes, ma'am. They were bloodshot and baggy, which that will happen when you're extremely tired.
So in your opinion, did her eyes look as if that could be true, that she could be tired?
Yes, ma'am.
She told you she was tired.
She did.
You had already observed some bad driving. Did you have concerns at that point about her continuing to drive?
I did.
So based on those concerns, well, before we get to that, did you also ask her for information about where she was coming from, where she was going to?
I did.
Was she able to give you good answers?
She was not. I think she said she went and bought a car. When I asked where they were, I think I asked where they were or what they were out doing. She went and bought a car, and then I asked again later. She said they just went to Dallas to see family, I think, but didn't mention a car.
Did that cause you any concern as to whether she might be mentally confused?
It caused enough concern that I knew something wasn't exactly right.
So based on all of that, sir, did you believe it would be a good decision for you to allow her to keep driving down the road?
Right at that moment in time, no. I think she needed to get woke up.
So based on the fact that you did not think it was a good idea for her to continue driving, what did you do?
I went to go talk to the passenger.
Was there, how, other than the driver, the female you've been speaking with at that time, how many more occupants of the vehicle were there?
One
And what seat was that person in?
front passenger.
So you don't have a good feeling about her continuing to drive. You said you went to talk to the passenger. Is that correct?
Correct.
So at that point in time, I think you already told us that the passenger side is against the ditch side, not the road side of the roadway. What do you physically do? How do you make contact with the passenger?
Typically I'd walk up and tap on the passenger window, but I noticed there was a stick wedge down in the window that would prevent it from rolling down. So I just opened the door to speak to the passenger.
So based on what you observed, did you think the window functioned in such a manner that it could be rolled down by the passenger?
No,
And when you saw that, came to that conclusion, did you open the door?
I did.
What was your purpose in opening the door?
To talk to the passenger.
Did you reach inside the vehicle in any way?
No, I did not.
So when you opened the passenger door, what happened?
A black bag fell out and landed on my foot.
What did you do at that point?
I believe I apologized to the passenger that something fell out of the car, and I asked what it was, and the passenger had no idea what it was. So I placed it on top of the car.
Did you open the black bag and look inside?
I did not.
Did you continue your interaction with the passenger at that time?
Yes, ma'am.
And what, tell us about that.
At that time, that's when I placed him in hand restraints and detained him because he did not know what was in the bag. And for my safety, I obviously don't know what's in the bag. So it could have been a gun. I don't know. So he was detained. And
Did you ask for consent to search?
I did ask for consent to search.
Did you ask the passenger or the driver or both?
I believe it was the passenger's car. So I asked him.
And what was the response?
Response was no. That he don't consent to searches.
So the circumstance is you open the door, the black bag hits you, you don't look at it, put it on the roof of the car, you ask for consent and you're told no.
Correct.
Based on all of that totality of the circumstances, what did you do?
I called for a K9 unit to try to gain probable cause.
Does Canton PD have a K9 unit available?
Most of the time,
And who is that officer?
Officer Mattingly.
On this particular night, was Officer Mattingly available to come out?
He was available. He was not on duty, but he was available.
Do you recall, or does it reflect in your report how long it took for Officer Mattingly to arrive at your location?
I have a time where Officer Mattingly did arrive, but I don't know exactly when I contacted Officer Mattingly. I'd have to refer to a video.
And while you're waiting on Officer Mattingly, are you taking care of any other police business there on the side of the road?
I was still speaking with the occupants of the vehicle and trying to explain to them what was taking place and why I was doing what I was doing.
Did you run computer searches on them?
Yes, ma'am.
Did either of them have warrants?
No, ma'am.
Did you have any conversation with the passenger as to the black bag that fell out?
I did. Passenger, he did not know anything about the bag, never seen it before, but he said that he thinks possibly he did leave the sunroof open in Terrell at the Buc-ee's, and somebody might have put the bag in the car while they were inside Buc-ee's.
When Officer Mattingly arrived, did he run his drug dog on the vehicle?
He did.
Did the dog alert?
The dog did alert.
Based on the dog alert, did you conduct a search?
We did.
And did you search the car itself?
Yes, we searched everything after the alert.
Did you search the black bag?
We did.
What did you find in the black bag?
I believe it was 378 grams of methamphetamine.
And did you find any other contraband or narcotics in the vehicle?
I don't recall finding anything else.
So you told us Officer Whitus, that your car is equipped with a dash cam that activates with flip on the red and blue emergency lights, correct?
Correct.
Were you yourself also equipped with a body worn camera on this night?
Yes, ma'am.
Have you, at our request, come to our office and reviewed that camera?
Yes, ma'am.
Does it truly and accurately depict what happened on the side of the road on this night while you interacted with these individuals.
Yes, ma'am.
Do you see the passenger of that Honda Accord in the courtroom here today?
Yes, ma'am.
And can you identify him by what he's wearing for us, please?
Orange Van Zandt County Jail jumpsuit.
Your Honor, may the record reflect he's identified the defendant.
If we have other individuals wearing orange, don't see anything more specific about race.
Yeah, he's sitting next to his attorney right here with a bald head and a beard.
Court will, allow the record to reflect that this officer has identified the defendant in this case, Mr. J. Warren.
And may I approach Your Honor? Also, let me show you what's been marked, takes exhibit suppression 1 and suppression 2. Do you see those?
Yes, ma'am.
And do you know what those are, sir?
Those are in my videos.
Right. And how is it that you're able to say that those are your videos?
They got my initials.
And again, you've already testified that these are accurate
Yes, ma'am.
reflections of what occurred that night, correct?
Yes, ma'am.
Will all of these suppression 1 and suppression 2.
All right, there being no objections, that states exhibit suppression 1 and suppression 2 are.
Your Honor, we're not going to ask to publish those at this time, but they will be, of course, a part of the record for the court's review, and we'll pass those.
Thank you, Your Honor. Officer Wattis, did you have, other than reading the offense report you have in front of you now, have you had a chance to read that prior to testifying today?
I printed it late yesterday evening, so I hadn't had much of a chance to actually go over it.
Yes, sir. Wanted to ask you about a couple of things. Now, and you may not remember, but isn't it true that the vehicle that Mr. Penny was in was driven by the female driver, Ms. Andrea Sandlin, that they'd actually put their turn signal on in turn prior to taking the exit? Is that accurate?
I don't recall.
And the action that you felt like her maybe trying to get back on the interstate, it was, she drifted over and hit the line on the exit ramp. Is that what you recall?
Yes, sir.
Now, after you pulled her over, she indicated to you that she didn't have a driver's license and you had her step out of the vehicle, correct?
Correct.
Now, when you came up to the driver's side window, did they both indicate to you that there was problems with the windows and that's why she was opening the car door to talk to you? Do you recall that?
I do not recall that.
And you spoke with also the passenger when you came up there as well, or they both conversed with you when you were talking to Ms. Sand?
From the best I recall, I only spoke with the driver, but if the passenger said something, I don't remember.
Now, the sunroof was open on this car where you could like look in and speak to both individuals, correct?
I ain't that tall.
It was a little Honda Accord, right?
Yeah, I don't talk to the sunroof, and I didn't notice if it was open or not at that time. When I'm walking up on a car, I'm looking at hands. I'm trying to see where everybody's hands are at.
Now, from your report, it stated that you asked her to step out for two reasons. One, determine whether she was, under the influence. And I think you just testified whether she was either sleep deprivation or tired, or she was under the influence. Then also to get her credentials to see who she was, and she had a valid driver's license, correct?
Correct.
Now, I understand it's in your report, and I guess we can ask the court to look at it later. But during your interaction before you went up to see Mr. Penny, she never said she was extremely tired like you stated in your report. Did you get a chance to look at the video?
Did watch some of the video, but I didn't watch all of the video.
Okay. Well, isn't it true that when you're asking her where she's been, where she's gone, she never indicated, made a statement that she was extremely tired or even tired?
I would have to watch the video, but I don't believe I would put that in there if she didn't say it at some point.
Well, your conversations after you put Mr. Penny under restraint, I mean, y'all basically had half an hour to talk before the drug dog or the canine unit showed up, correct?
Yes, sir.
Okay. Is it possible that she mentioned being tired after Mr. Penny was under restraint?
I guess anything's possible, but I don't recall.
Now, you discovered, at least from what she told you or represented to you, that she did not have a valid driver's license, correct?
Correct. I believe she had one in the past, but it was suspended.
And your statement, at least in your report, you say you went, I went to ask the passenger if he had a valid ID so maybe he could drive since she was extremely tired. Was that your only concern when you went over to check with the passenger, was the fact that the driver you thought the driver was extremely tired and that's the only reason you went over to the passenger side to see if maybe he could take over?
In my report, it stated, I guess they went and bought a car. And I asked if it was a car that she was just driving. And she said, no, another car, and she's going to Indiana. So I asked if she was going tonight, and she said no. Then I asked again where they're coming from, and she stated Dallas. She's got family there. So in my training and experience, and I do work a lot of criminal interdiction on Interstate 20, when I do ask questions and talk to people and things don't seem right to me, then I like to dig a little deeper to make sure there's not criminal activity taking place at that time or about to take place. So I was going to speak to the passenger regardless.
So your report, where you state that the reason you went over there was to see if he had a valid driver's license and to see if he could drive because she's extremely tired. Are you saying that's not the reason you went over there?
No, that is one of the reasons, but not the only.
Now, in your training, in your experience, do you typically, when you go up to talk to whether it's the driver or the passenger, do you physically open up a car door without permission?
I have many times asked someone to step out of the vehicle, and I went ahead and opened the door for them.
Well, my question is, in your training, are y'all taught to go and open somebody's car door? Or are you taught to ask them to either roll down the window or to open the car door themselves? Or do you actually take it on yourself to open the car door?
No, we would typically ask, do you mind rolling the window down? But with the wedge in there, I knew it wasn't going to roll down.
Did you ask him to roll down the window or ask him to step out?
No.
Now, if the video shows you'd spoken to him, whether through the open driver's side door or through the sunroof, you were communicating with him without having to open the car door, correct?
I don't recall communicating at first on the initial stop, but I mean, I would rather stand on the passenger side and communicate with the passenger.
And I think you stated typically you just kind of tap on the window and ask them to roll it down, correct?
Typically.
Okay, but you didn't do that in this case.
Not with the wedge in there.
Now the wedge, I'm assuming could have been pulled out to roll the window down.
Possibly.
Right. Did you ask him or give him the opportunity to roll down the window?
No, sir.
Now, if she wasn't extremely tired, would that have negated your purpose of going to talk to the passenger?
I can't. I mean, that traffic stop could have went several different ways. I mean, I can't really answer that.
She showed no indication of being under the influence as far as smell alcohol or unsteady on her feet, correct?
Correct.
Now, did you ask her like how much sleep you had? Are you extremely tired? Are you tired at all? Did you question her about her alertness?
No, the best I recall is when she told me that she was tired.
Now, isn't it true that after the stop and after the K-9 unit showed up, that you actually let her drive from the scene? Like you had no problems letting her leave in the same vehicle?
Yeah, I think she had gotten woke up pretty good by that time.
Now, how long after Mr. Penny was put in restraints, do you recall how long it took for the K-9 unit to show up?
No, sir. I have the time here, Rock, but I don't recall the time that I called.
If I said it was almost exactly half an hour, would you have any reason to dispute that?
Would I have any reason what?
To dispute that?
No, sir.
And how long did it take for you to actually get in your vehicle and run their names from the identification that they had given you and get that information back to find out there was no warrants or that the car was insured?
I'm gonna guesstimate 10 minutes.
So after you discovered that she did not have a license, that there were no warrants, that the vehicle was insured, basically that completed the purpose of pulling them over that evening, correct?
It completed the purpose of that, but during that time I had developed reasonable suspicion beyond that.
And your reasonable suspicion was essentially, I don't want to put words in your mouth. I mean, just briefly explain to the court what your reasonable suspicion was.
It was a bag that nobody knew what it was or what was inside of it, and no one would claim ownership of it.
Now, at least as far as your subjective mind, isn't it true that you actually got in the squad car and you called someone and said, hey, there's a suspicious bag, nobody's claiming ownership, is that probable cause? You actually had to call and ask that question to someone, correct?
Well, at that point, it was basically abandoned when it hit the ditch because nobody claimed it. So with it being abandoned, I could have probably opened the bag, but I would rather have gained probable cause and do it the right way.
So even in your mind, at least at that point, there's no probable cause to at least look into the bag.
I could have looked in the bag, being that nobody claimed it and it was not in the car anymore and it was laying in the right of way of the ditch, but I opted to call for a K-9 unit to try to gain probable cause.
And if it took you the 10 minutes to run their names and everything, you would agree that for 20 minutes, there's really nothing you can do other than sit on the side of the road and wait for the K-9 unit, correct?
Correct.
Now, and I'm sorry, I just want to cover one last thing. When you walked over to the passenger door, I just want to make this clear for the record. You didn't tap on it or any way motion for the passenger to either open the door, roll the window, or speak to you, correct? Either by hand motion or tapping. You didn't make any gestures for him to.
I'll agree with that.
Okay. And would you also agree you didn't verbally ask the passenger to roll down the window, open the door, or anything like that?
To the best of my knowledge, no.
Passwords.
Briefly, Your Honor. Officer Whitus, when you approached the passenger door and saw that stick wedged into the window there, did you believe that the window could be rolled down from the inside?
I figured the window was broke and this wedge is what was holding it up.
I have a picture in my mind of the stick wedged in the window. Could that stick have been removed from the inside of the vehicle?
Yes,
While the person was inside, they could have reached out and removed that stick?
from what I remember, I don't know if the wedge was outside or inside the car.
Ah, okay, okay. Okay. But with it in there, you didn't believe the window could function and roll down?
I figured if the wedge was removed, the window would just fall down freely.
Council asked you about the time for the computer return. All the times that you've estimated here will be shown exactly on the video. Is that correct?
Yes, ma'am.
And the black bag that fell out when you opened the passenger door, did you know of that black bag's existence before you opened the door?
No, ma'am.
Did you know that anything at all was going to fall out of the door when you opened it?
No, ma'am.
Was your purpose in opening the door in any way to search that vehicle?
No, ma'am.
Did you reach any part of your body inside that vehicle?
No, ma'am.
Once no one claimed the bag, based on your training and experience, did that raise your suspicion level as to criminal activity?
It did.
And what type of criminal activity would that have been?
At the time, I didn't know. I didn't know if there was narcotics in there, if there was a gun in there, stolen property. I didn't know what was in it.
In your experience, when someone, one person or group of people in a vehicle all disown something within that vehicle, in your experience, is that more likely, less likely, even odds that it's contraband?
It is something illegal.
So at that point, did you have more reasonable suspicion that there was criminal activity than you did when you say first stopped the car?
Yes, ma'am.
I'll pass with instruction.
Sorry, Your Honor, just briefly. If the video shows that the wedge was inside the passenger door, Mr. Penny could have easily removed it to let the window roll down, correct?
That is correct.
And when the package fell out, there was nothing readily apparent by the size of the package or bulges or anything that at least through your eyes would indicate that there was some contraband inside, correct?
It hit my foot. I could tell it was pretty heavy. And I immediately said, I'm sorry. And then asked what was in it, I believe at that time, and nobody knew.
But my question is, at least, I mean, it didn't look like the shape of a gun or the shape of,
Correct.
there was nothing readily apparent that made it look like it was contraband, correct?
Correct.
And there was other packages that were clearly visible inside the car once you looked inside, correct?
I don't recall.
And after you searched it, there were other bags and other items, correct?
So I don't recall what was in the car.
Now, you put Mr. Penny under arrest, but you didn't ask the driver, hey, at least at this point, whether that was her bag or she had knowledge of the contents, correct?
Mr. Penny at that time was just detained. He was not under arrest, but the bag was in between, had to have been in between his right leg and the door for it to fall out. So he would have been the one that had direct knowledge of that bag.
Could it have been like behind his seat, in the back, leaning against the door and fell out from behind his seat?
No, sir.
That's
Nothing further, Judge.
All right. Objections to the officer, modesty, violence used.
No, Your Honor.
Thank you, sir.
Thank you.
For any additional witnesses or evidence.
No, Your Honor, state rests.
Your Honor, it's rest as well. I would just kindly ask the board if I could submit just a couple of cases. I was sure with the council. There's been an honorable, I would ask the board for some findings of fact and one of, well, I'll just present those then, just depending on the ruling.
Long before you submit your cases.
I can get it to courts tomorrow. Forgive me, I had court in Dallas this morning and I thought I had it filed, but
Do you all want any kind of closing arguments on the motion?
No, Your Honor.
All right, or we'll set Mr. Denny for rock call on your calendar.
yes, sure.
You look at August 8th, 10th, or 22nd. 18th or 22nd.
Yeah, it's pretty good, but
Well, we'll set Mr. Denny for ruling on the motion to suppress and alcohol August 10th. I anticipate having a to you much in advance of that. So I'm gonna go ahead and set it on the docket just in case. It'll be at 1:30. And I just asked council, could I supply the report to do so as soon as possible? Or will take into consideration under advisement at this time. As motion to suppress the testimony of Officer Whitus and the court will review its entirety of both state's exhibit, suppression one, suppression two. If there's nothing further, that will be adjourned. See everyone back on August 10th. Thank you, Your Honor. Thank you, respect.
Thank you. Sorry.
No shut your eyes. Oh, all that's. Or are you ready to take both of them back? She's gonna take all three. Take all three, okay, let's, come on.
Throughout, Your Honor, we're ready when you are.
I'm ready. We got
Mr. David, DeAndre Davis,
Davis. DeAndre Davis, CR 23-27. Right, let's see, Mr. Davis will be pleading today, Mr. Schmidt.
correct.
Okay. And let's see, before we get going, it looks like Mr. Davis charged with a third-degree felony, evading arrest, potential vehicle, plea agreement appears to be plead guilty, recommendation is 4 years in prison. 1245 being, if you filled it, ID is fugitive, and also possession of marijuana. No fine, court cost $290, and then 216 days credit towards the, is that right?
Yes, sir.
All right, Mr. Davis, sir, you raise your right hand on the patient under oath. Mr. Davis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, thank you. Your name is DeAndre Davis, is that correct?
yes,
Mr. Davis, are you a United States citizen who reads, writes, and speaks English?
yes,
Have you ever been diagnosed with a mental condition?
no,
Mr. Schmidt is your attorney. Are you pleased with the work that he's done for you?
yes,
You feel like you've had enough time to talk to him about your case and all of your legal questions answered?
yes.
Is there anything, Mr. Davis, about this paperwork that you've read over and signed today that you do not understand?
I understand it all.
Okay. Mr. Schmidt, do you believe Mr. Davis to be competent and that he's entering into this plea agreement intentionally, knowingly, voluntarily?
I do.
Mr. Davis, you are charged by indictment with the third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment, not less than 2 years in prison or more than 10 years in prison, and also carries a fine if imposed of not more than $10,000. Do you understand that full range of punishment?
Yeah.
Do you understand the plea agreement in your case? That's what you're asking the court to approve.
Yes,
All right, Mr. Davis, how do you plead to that offense?
yes,
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
which, yes,
Has anyone threatened, forced, or pressured you to plead guilty today?
oh, sir,
All right, court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial position. Is there anything further from the state
No, Your Honor.
or the defense?
Nothing further.
The court's going to review the evidence. And Ms. Curry, I see in the indictment that there is an enhancement paragraph so that there's no confusion. It's the state abandoning the enhancement paragraph.
Yes, Your Honor.
Mr. Schmidt, would you do me a favor? Would you mark through the enhancement paragraph 1 as contained in the indictment stipulation and right abandoned by the state?
Judge, on my documents, those are, did you say that one more time? I'm sorry.
That's okay. On Mr. Davis's indictment, I think there's an enhancement paragraph here.
There is.
Since he's not pleading true to that, it's not being reflected, but I don't want there to be any confusion at TDC. I would just ask that you just mark through it for the court and abandoned by the state. Ms. Curry says that she abandoned it.
Yes, sir. Yes, sir. Gotcha.
All right, the court's reviewed the evidence. I do find there's enough evidence to convict Mr. Davis of this offense. The court does hold on the agreement today. The court convicts DeAndre Davis of evading arrest or detention of the vehicle. Third-degree felony, assesses his punishment pursuant to the agreement at 4 years confinement. The Texas Department of Criminal Justice Institutional Division. Court dismisses under section 1245 and also under DA 2022-395. Failure to ID fugitive and also DA 2022-1394 possession of marijuana less than 2 ounces. The court also imposes court cost of $290, reimbursement fees $20. The Court awards Mr. Davis 216 days for towards assistance for time he has spent in jail on this case. Mr. Davis, you hereby remain in the custody of the sheriff, so we carry out the terms and conditions of the sentence. Have you step over with the deputy?
Again, I mean, I do it, but they probably can't.
Do you like next, Mr. Chairman?
Mr. Tesno,
David John Pesnell, CR 21-183.
Good afternoon, Judge Martin.
Good afternoon, sir. All right, what are we doing on Mr. Pesnell today?
Judge, negotiated with the state that the state would withdraw its motion to adjudicate amend Mr. Pesnell's community supervision, extend him for an additional 1 year period of time, and place him on ISP.
Mr. Schmidt, forgive me if I didn't hear you. Did you say there's any jail time as addition? Or is it just withdraw and extend 1 year placement on ISP?
I think it's withdraw, placement on ISP, 1 year extended. I don't see, and we didn't discuss, as I recall, jail time ACOP. It's not on the document that I have before me.
Is the probation department supportive of this agreement?
Yes, sir.
All right, the court will, let me do this, Mr. Pesnell, raise your right hand. Please both ask you a few questions. You swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, Mr. Pesnell, you put your hand down. Mr. Pesnell, has anyone threatened, forced, or pressured you to agree to an extension of your probationary period for an additional 1 year?
Yes, sir.
They have pressured you. Who's pressured?
Oh. No, sir, they did not threaten or pressure me.
Okay. Has anybody threatened or pressured you to make you feel like you had to make an amendment to include placement on the intensive supervision case?
No, sir.
And you're asking the court to approve this agreement today, is that correct?
Yes, sir.
Can you tell me in your own words why I should do this, considering you're already on probation, you've had multiple positive drug tests, alcohol tests, and violations? Why is it I should continue you on probation?
Well, sir, I was actually clean a week before I came in here, and since I've been in here has been a great cleanup time for me, and I've come to realize that if I don't clean myself up, I'm gonna be spending a lot of time in prison, and I like my freedom, and I'm gonna do everything I can from this point forward, which includes to move to Canton, so that I can make sure that I get my probation taken care of and be a productive member of society.
Are you going to address your drug problem?
Yes, sir. Every day.
No, how are you going to do it?
I'm in the counseling over there at the center. And I want to find more counseling. I'm ready to go back to church. I need to stay on it. I need to stay on it and not think that I'm above being clean.
What kind of sentence is hanging over your head if you're not successful?
Well, I know that my charge was 2 to 20. That's all I know.
Yeah, so you're right. So the court, if it found based on evidence that you violate, I could do that today.
Yes, sir. My attorney told me that all he has to do is prove one count, and I can be revoked.
That's right. And I could put you in prison for up to 20 years.
Yes, sir. And also, I want to apologize for my little stunt I pulled when I was in court last time.
All right, I'll tell you what, Mr. Pascal, I'm gonna put the ball in your court. We're gonna see if you can handle it or not. If you can handle it, then I think we both should know. I know what's gonna happen next time we go down. And you
Yes,
should
sir.
too. All
Thank
right, we're going to approve the agreement or finds that the probation department is supportive of this agreement. Court puts a lot of discretion in that opinion, so the court hereby extends the probationary period of Mr. David John Pesnell for an additional 1 year. Court amends community supervision or placement on the intensive supervision case.
Good, Martin.
So that now you get out, go see your probation officer, do what you're supposed to do.
Yes, sir.
Who's next, Mr. Shannon?
Alicia Joyner.
Joyner. This is CR 2127, say versus Alicia Renee Joyner. What are we doing on Miss Joyner today?
Judge, we negotiated with the state to withdraw the state's motion to adjudicate guilt, to place Ms. Joyner back on probation, to extend that for a period of an additional 1 year, 67 days in the county jail as a condition.
Ms. Joyner go to CP in our previous motion? Is that what count 8 is? Is that when she was not successfully discharged? Is that what the list? Is that right?
I didn't hear you, Judge.
I said, count 8 in the state's motion. Does that mean that she was unsuccessfully discharged from safety or some other rehab?
Wasn't safety. Go to safety.
I've been in.
It was something else. What is it? Counseling.
Okay, substance abuse evaluation. In light of what's been alleged by the state, Mr. Schmidt, make your argument for me as to why I should put her back on probation. She's already on probation.
Do we recall her case, Judge?
Yes, sir. Mr. Manning, ready on the?
Your Honor, let me go see.
Okay. Mr. Manning, are you ready on anything?
I'm currently waiting with some clients.
They're getting them out of the gym. It'll be just a minute.
Okay.
I don't know. Fix the other.
We ready on Mr. Manning?
Judge, we'll start with Mr. Jackson.
All right, Mr. Jackson. All right, this is Quavian Antoine Jackson, CR 21361.
That's great.
Let me see if I have Mr. Jackson. I don't have any paperwork on Mr. Jackson. What are we doing with him today?
Judge, I'm having a hard time hearing you.
Yeah, I'll tell you what, it's bad, I guess. you guys are freezing up. I said, what are we doing on Mr. Jackson?
Judge, there was a motion to adjudicate filed. After negotiating with the state, we reached an agreement to withdraw the motion to adjudicate, extend probation for 1 year. He's gonna do ISP reporting here in Van Zandt County. He was previously reporting out of county. And there's gonna be, as a sanction and a condition of his probation, he is going to serve 45 days in the county jail. And he does not have credit for the entire 45 days. He only has credit for 33 days at this point in time.
All right, and Mr. Manning, before we go any further, I see that Mr. Jackson's already on community supervision. Can you make an argument as to why I should go forward with considering this?
I'm sorry, I'm having a hard time hearing you, Judge.
Can you hear me now?
It's very faint and we got lots of noise back here.
Okay. I'll tell you what, let me. Hang on just a second. Mr. Manning, can you hear me now?
Judge, I can.
All right, let me know if it cuts out. I don't know what the issue is. I'm not making adjustments or anything. I just don't know. There's no.
I can tell you you're much clearer and louder than you were previously. So I don't know what happened, but it is working better now.
Yeah, I didn't do anything. So, all right. So Mr. Jackson's already on probation. Tell me why I should even go further in considering this extension and ISP and why do that? He's already on probation. What's the argument for that?
Sure, Judge. Mr. Jackson's a young man. He has, up to this point, doesn't have criminal history or significant criminal history. He was put on probation for a THC CBD type offense and was put on deferred probation. When he was put on deferred probation, he did not miss any of his reporting over in Smith County. However, he was continuing to struggle with use of marijuana. And so he was on sanctions court and he appeared at his sanction court's appearances. And it wasn't until I believe there was I believe the ultimate, I guess, final straw was that on March 16th of 2023, that it's alleged that he failed to appear and report for a UA test at a random UA line in Smith County. My client has a defense for that, and I've relayed that to the state as part of our negotiations. And so we felt it was in the community's best interest, as well as Mr. Jackson's best interest, to attempt to give him another opportunity at reporting not in Smith County, but here in Van Zandt County, and on a weekly basis, getting drug tested regularly. He has, and I can call my client if necessary for testimony, but he has transportation. He lives in the north side of Tyler, and he has transportation both with his mother and his sister to be able to get to and from those weekly meetings. Additionally, Judge, he has a job lined up so he can begin payment. He wasn't previously working because he was helping his family by caring for his niece while other members of his family were working. And the conversations I had with Mr. Jackson were he wasn't taking his probation seriously, as it is a serious offense that he is on probation for. The range of punishment is great, especially for someone of his age. And we'd like for him to avoid being a felon at this age. And so Ms. Curry was gracious enough to consider the mitigation that was brought, and based on his continued participation of attending probation in Smith County, we thought it would be a good fit to give him another chance to maybe try reporting here to Van Zandt County under strict supervision and see if he can get this marijuana problem solved.
Thank you, Mr. Manning. And probation, are you in support of this agreement?
Your Honor, I spoke with his indirect technician, Danielle Griffith, who supervised him, and she said she was not in agreement due to his lack of participating in classes, no transportation. He's had several positive UAs, and he's also been in sanctions court several times and hasn't complied with that as well.
Thank you, Mr. Burns. Mr. Manning, can you address the lack of transportation? Is that an issue?
Judge, as I said, he has up to this point never missed a probation appointment or a probation sanction court setting. There was some issue with the scheduling of the classes. Like I said, he was caring for his niece who was in need of a young child in need of childcare. And I told him, I said, that's honorable and noble and stuff. At the end of the day, he has bigger responsibilities right now, and those are to comply with the conditions of probation. And he's going to just have to figure out a way to balance those responsibilities while putting a priority on those conditions that he's been ordered to do.
Yeah, it sounds like, Mr. Manning, you've been having the same conversations that I had with your client over 4 different sanction court hearings, because I was trying to prevent this day. I was trying to prevent the day that he was in a jumpsuit locked up in the back of the jail talking about going to prison. I mean, I tried hard. But it's hard for me to look at this and think that anything's going to be different.
Well, Judge, as I was not representing him during the course of his sanctions court, I don't know what did or didn't happen. I imagine those admonishments were given by the court. However, that's part of the reason for his sitting in jail as a condition of probation now, is he's not getting out today. He has, by my count, about 12 more days that he's gonna be sitting here thinking about the plan that he and I have discussed to follow through with what he's been ordered to do. As I said before, and I started off with, he's a young kid. And I think that someone in his situation, given a felony conviction at this stage of life, is not insurmountable, but it definitely puts him in a position that, unfortunately, statistics show this is not useful to avoid reoccurrence of crime. That cycle, once it begins, is tough to break. And so I think, based on my conversations with my client, he's understanding that we're trying to avoid starting that felony conviction with this. I've warned him, it's not going to be easy. Reporting weekly, doing weekly UAs, that type of thing is not going to, it's not going to be like it was before, where he was just showing up once a month. So that's, I think, and my client would agree, that's the change in his perspective from prior to this present time, is that he realizes the severity, he realizes what's required of him, and he has a plan for that, and he has the ability to enact that plan.
Thank you, Mr. Manning. I do appreciate that. Mr. Jackson, raise your right hand. I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, put your hand down. Mr. Jackson, I'm gonna go against my gut here. I'm gonna approve your agreement. But I'm going to tell you, I don't think you're gonna do it. I don't think you're gonna make it. Your probation officer doesn't think you're gonna make it. It's because you've given us a pattern and a history, multiple sanctions for it. I try to keep you from being where you're at today. But here you are. I don't think you're gonna take it serious. I'm glad Mr. Manning still has a lot of optimism with you, but I don't. But nevertheless, I'm gonna approve the agreement and hope you prove me wrong. If you don't, then I'm not gonna take any, it's not gonna be a win for me if I'm right. I'd rather you prove me wrong. I'd rather you approve your probation, Officer Vaughn. Okay?
Yes, sir.
Mr. Jackson, has anybody threatened, forced, or pressured you to make you feel like you had to extend your probationary period for an additional 1 year?
No, sir.
You agree with amending your probation to include additional jail time, 45 days in jail, with you receiving credit for 33 days, and you still have 12 more days to serve. Do you agree with that?
Yes, sir.
Has anybody threatened or forced or pressured you to agree to those things?
No, sir.
All right, court hereby grants the state's motion to withdraw the motion to adjudicate guilt or to extend its community supervision for a period of 1 year. Orders him to do 45 days confinement in the Bates County Jail, gets credit for 33 days of time served. Court will continue on continuing to extend his community supervision. All right, make sure you sign your paperwork. You get out of this probation officer. Mr. Manning, who do you want next?
Judge, ready next on Mr. Mark Walcott.
CR 21-348. What are we doing on Mr. Walcott?
Judge, I showed CR 21-347. That may be a mistype on the paperwork. Let me check.
Could be wrong on my docket. That's my docket. My docket's showing 248. Let me check. You could have had multiple cases. Right, Mr. Manning, I think that he had 2 cases, both 347 and 348. The motion to revoke appears to be filed in 347. So my docket says 48, so it looks like it's the
Okay.
incorrect one. So 347 appears to be right. Let me confirm that by looking at the state's motion.
And Judge, I have a copy of state's motion, and the motion is filed from September 7th, 2022 in CR 21-347.
That's correct. You see that. Mr. Walcott, if you'll raise your right hand, issue an oath. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Walcott, you appeared before the court. You appeared before the court on June 14th of 2022. You pled guilty and were convicted of the state jail felony offense of possession of a controlled substance. The court heard your plea agreement that day, approved your plea agreement, assessed your confinement at 2 years in the state jail division of TDC, and ordered you to pay a $2,500 fine. The court then suspended that sentence based on your plea agreement, placed you on probation for 5 years. And it was during that period that the state filed this motion to revoke your community supervision in September of last year. And in that motion, they alleged 8 separate counts of ways that you have violated. Are there more counts than that, Mr. Manning?
Judge, just to be clear, make sure I understood, that was a state jail offense. Is that correct?
That is correct.
And that there was 8 counts. We were served with a copy of that includes 8 counts, and he is pleading true to all 8 of those counts.
All right, does he waive the formal reading of the state's motion?
He does.
All right, Mr. Walcott, are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Like you've had enough time to talk with him about your motion to revoke and had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
All right, I see the agreement is that you're going to plead true to all counts, that your community supervision would be revoked and you would be assessed 9 months in prison. You'd also be ordered to pay your financial obligations, fines, court costs, reimbursement fees, and restitution. And you would get 147 days credit towards your sentence for the time you've already been in jail. Is that your understanding, Mr. Walcott?
Yes, sir.
All right, Mr. Walcott, then how do you plead to counts 1 through 8 as alleged by the state? Are those counts true or not true?
True.
Are you telling me that those counts are true because in fact they are true? You're not just saying that to get a plea agreement. Is that correct?
They are true.
Thank you, Mr. Walcott. All right, Mr. Manning, any objection to the admission of the defendant's waiver of rights of plea of true and evidence?
No objection.
That's admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Just briefly, Judge, I explained to Mr. Walcott, his financial obligations and explained to him that he will be, upon being released from state jail, required to make arrangements for a payment plan as he does not have any money on his books that would fall under attachment A. Additionally, Judge, I spoke to Mr. Walcott and he would like to request from the court, as do many of my clients, the good time credit that comes with the state jail offense under diligent participation 42A 559 in the Texas Code of Criminal Procedure. I explained to him the process for that, and he is currently participating in AA here in Van Zandt County Jail and intends to, when he gets to state jail, participate in the programs there as well, as a measure of showing his desire to have that diligent participation credit. I also explained to him that the court does not presumptively allow that, but that we could make that request today, and that you would consider that.
Absolutely. That is noted and your assessment is correct, Mr. Manning. That is the procedure in which the court reviews the diligent participation credits.
With that, Judge, I have nothing further.
All right, All right, then based on the evidence, the court finds that Mark Harris Walcott has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court hereby revokes his community supervision, assesses his punishment at 9 months confinement in the Texas Department of Criminal Justice State Jail Division, orders him to pay the balance of his financial obligations, and awards him 147 days credit towards his sentence for the time that he has spent in jail on this class. Mr. Walcott, you're hereby remanded to the custody of the sheriff, so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingered.
Thank you.
You're welcome.
Are you?
Who's next, Mr. Reed?
Judge, ready on Mr. Jonathan King.
All right, Mr. King, you'll raise your right hand and serve in place under oath. Mr. King, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you for lawyer. Mr. King, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to talk with him about all of your cases and that you've had all of your living questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. King to be competent today and that he's entering into this agreement intentionally and voluntarily?
I do, Judge. Throughout my representation of Mr. King, he has participated in the defense of his case, providing mitigation and exculpatory evidence that we've discussed to lead towards this plea bargain today.
Okay. All right, Mr. King, let's see here, in cause number CR 22331, you were charged with a third-degree felony offense, assault of a pregnant person. It appears today that you would be pleading guilty to a lesser included offense of a class A misdemeanor assault, causes bodily injury, family member. Plea agreement that carries a range of punishment of confinement in the county jail for a period not to exceed 365 days or a fine of more than $4,000. plea agreement indicates that you would, the punishment would be recommended at 112 days confinement in the county jail and credit for all 112 days of time served. In addition, a $1,000 fine plus court costs and reimbursement fees. And I see that the state would be dismissing cause number CR 22332. And that is a unlawful possession of firearm by a felon. Mr. King, is that your understanding of the plea agreement today?
Yes, sir.
All right, so to the lesser included offense of class A misdemeanor assault causes bodily injury and family violence, how do you plead?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime? You say yes, I'm sorry, it might just be bad connection, yes?
Yes, Your
Okay. And Mr. King, has anybody threatened, forced, or pressured you to plead guilty to this offense?
No, sir.
All right, court does accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
Judge, no objection per se to state's evidence. I would like to clarify, though, that an affidavit of non-prosecution was filed in this case, specifically declaiming certain actions or the way certain things appear. And so while we agreed to the lesser included offense, we don't feel like that the behavior or actions that occurred are portrayed completely in states one accurately as my client is pleading to that offense.
All right, thank you, Mr. Manning. Anything further from the state?
No, Your Honor.
All right, court's going to review the evidence. All right, court has reviewed the evidence. Court finds sufficient evidence to convict Mr. King of this offense. Court will follow the plea agreement. Court hereby convicts Jonathan Contrell King of assault, causes bodily injury of a family member involving family violence. Class A misdemeanor, assesses his punishment at 112 days in the county jail, gives him credit for 112 days of time already served. Assesses a $1,000 fine, $270 court costs, $655 reimbursement fees. Mr. King hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you get out of jail, you do need to report to the courthouse, pay your fines and court costs and reimbursement fees, or if you cannot discharge all those at once, you need to meet with the court compliance officer and set up a payment plan. Do you understand?
Yes, sir.
Failure to comply with paying off what you owe will result in the court issuing a warrant for your arrest. Please step over the deck. Court also, for the record, is dismissing CR 22332 unlawful possession of firearm by felon pursuant to the plea agreement. Who's next, Mr. Manning?
Just next, ready on Mr. David Simpson.
All right, Mr. Simpson. David Keith Simpson, CR 2375. Mr. Simpson, if you'll raise your right hand, sir, I'm going to place you on the oath. Mr. Simpson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, sir.
Lower your hand. All right, Mr. Simpson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
Can you tell me about that?
I have bipolar depression and social anxiety, among a couple other things. I make medications here in the jail by Lisa, the nurse. It's like 12 different medications. And I also had a heart attack here. I went to Tyler to the hospital and they gave me medications and it's taking care of everything very well, sir.
All right, thank you, Mr. Simpson. Mr. Manning and Ms. Courier, is there any claim restitution?
Judge, I'm having a hard time hearing you.
Is there any claimed restitution on the medical issues with a trip to the hospital? Is there any indigent health claims?
Your Honor, we just received a victim impact statement on this case yesterday.
Ms. Curry is reviewing her records right now, Mr. Manning.
Yes, Judge.
No restitution, Your Honor.
No restitution to the sheriff's office or anything for any indigent health. None was requested.
Correct.
Okay. All right, Mr. Simpson, do you feel like you have a rational understanding of what's going on here in court today?
Mr. Dixon.
Is there anything that you're confused about or that you don't understand with all of the paperwork that you signed and the discussions you've had with Mr. Manning?
No, sir. Mr. Manning made it all clear.
Okay. And Mr. Manning, do you believe Mr. Simpson to be competent today despite his mental health issues?
I do, Judge. He was rather anxious about proceeding because he had a lot of questions, and we took quite a bit of time prior to today's hearing discussing the plea and what that would entail, what it wouldn't entail. And when we got here today, I also reiterated some of those points and was able to answer his questions. But I believe that he does understand what's happening and he is ready to go forward freely and voluntarily.
All right, thank you, Mr. Manning. All right, Mr. Simpson, you were indicted originally with what appears to be a third-degree felony offense of assault of a family or household member with previous convictions. But the plea agreement before the court is you would be pleading guilty to a lesser included Class A misdemeanor offense of assault causes bodily injury, with a recommendation that you be sentenced to 151 days in jail, with you receiving credit for all 151 days of time already served, with a $1,000 fine, $555 in reimbursements, and $270 in court costs. Is that your understanding, Mr. Simpson, what you're asking the court to approve?
Yes, sir, it is.
All right, Mr. Simpson, to the charge of Class A misdemeanor assault causes bodily injury, how do you plead?
Guilty, sir.
Are you pleading guilty to that offense because you are guilty of committing that crime?
No, sir.
No, sir.
Oh, I'm sorry.
It's okay. So you're pleading guilty because you are guilty. You're not telling me you're guilty just so you can get out of jail on this plea, right?
No, sir, I'm sorry.
Okay. All right, no problem. Court hereby accepts the defendant's plea of guilt at this time. Mr. Manning, any objections to the state's evidence supporting the plea?
No objection to states one.
States one is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, I would just say for the record here, it was discovered, drug charge by Mr. Manning, that the defendant in fact did not have a prior assault family violence conviction. And that's part of what it went into this plea agreement. He had a prior successful deferred assault family violence. So that's part of what it went into this plea agreement. I would strongly encourage him to continue his mental health treatment because I do have fears that without that, he might wind up back.
Did you hear that, Mr. Simpson? Did you hear what Ms. Curry said?
Judge, it was a little bit hard to understand, but I have had those type of discussions with my client as well as discussing how alcohol can affect his medication and his ability to reason through certain situations. So we've had those discussions previously.
All right, thank you, Mr. Manning. All right, court's going to review the evidence briefly. And just so I'm clear, it's assault causes bodily injury, no finding on family violence. Is that correct?
That's correct, Judge.
All right, court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Simpson of this offense. Court will follow the plea agreement. Court hereby convicts David Keith Simpson of the Class A misdemeanor offense of assault causes bodily injury. Assesses his punishment at 151 days in the county jail, issues him credit for time served, orders him to pay a $1,000 fine, $270 court cost, $555 in reimbursement fees. Mr. Simpson, once you are released from custody, you need to make arrangements to come to the courthouse and pay your fines, court costs, and reimbursement fees. If you cannot pay them all at once, you will need to make arrangements on a payment plan and be diligent about paying that off. If you are not and you do not pay, then the court will issue a warrant known as a capious pro fine for your arrest. Do you understand that?
Yes, I do.
All right, and I concur with Mr. Manning and Ms. Curry. It's very important that you stay on your mental health medications, lest you end up right back in the same place with a higher charge.
Yes, sir.
All right, please step over with the deputy. You're remanded to their custody so they can carry out the terms and conditions of the sentence.
Thank you, sir.
You're welcome. Who's next, Mr. Manning? And Ms. Curry, do you have the victim impact statement that I need to sign and send to your victim assistance coordinator? I didn't see that. Go ahead, Mr. Manning. Are you ready on those?
Judge, I have. Miss Abraham has an announcement.
That VIS should be attached to your docket.
To my docket? Good.
Yes, sir.
All right, I'll find it then.
Okay.
Oh, you have it, Judge?
Yeah, she said, I got a bunch going on, so I'm sure.
Okay.
The paperwork's. Are you ready, Mr. Manning?
Judge, ready on. Resets. For Mr. Cannon Racco.
Cannon, Nash, Racco, CR 21-90. Motion to revoke. Go ahead, Mr. Manning.
Judge, I think I might have butchered that. I've struggled to pronounce his name right every time, so.
Is it Racco?
Raco.
It's Racco, Judge.
We're never gonna get that right, Mr. Racco, so you got to just give us, some grace going forward.
Yes, sir.
Judge, I was recently appointed on his case and the motion. I have not received a copy of the motion at my last check, but I have discussed with him and have a general idea. We request a reset to see if there's any negotiation to be done on his case, as well as to see if there's any defenses available.
Remind me, Mr. Manning, of your schedule. Are you available July 25th?
Judge, I believe so. Let me double check that. Yes, Judge, I am available on the 25th.
Okay, and I'll ask Ms. Taberham to make a note to make sure that we provide you with a copy of the motion to revoke. Ms. Curry, is the motion to revoke not uploaded in your online discovery?
I can get it uploaded, Judge.
If you'll upload that for Mr. Manning. All right, we'll reset Mr. Racco for motion to revoke hearing on July 25th. You're good, Mr. Mayor.
Judge, last one I have is here presently is Mr. Randy Leonard. Sorry, Randy Young.
All right, Mr. Young. Randy Leonard Young, CR 22349, Docket call, go ahead, Mr. Mayor.
Judge, we are not ready at this time. We would request a reset. I was given a new offer yesterday and have not had an opportunity to discuss that with Mr. Young. Additionally, Judge, there are some additional matters that need to be taken care of before we make a final announcement on Mr. Young's case.
All right, court will set Mr. Young for docket call on July 25th. We have anyone else that's ready?
Judge, at this point, I still have some paperwork. Mr. Lyons, and I'll have an announcement on him and Mr. Ozuna.
Okay, yes, sir. Thank you. Mr. Schmidt, you ready on anyone?
You recall, Joyner, if you like,
Say that, I didn't hear you say that one more time.
Alicia Joyner, recall.
Ms. Joyner. All right, we are back on CR 2127 State versus Alicia Renee Joyner. I think when we left off, I was just asking, what's the justification for putting Ms. Joyner back on probation, considering her issues on probation?
That's correct, Judge. If the court, like I briefly call my client, she can explain to the court why she should be placed back on probation.
Okay, Ms. Joyner, if you'll raise your right hand, I'm going to place you under oath. And do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead, Mr. Schmidt.
Thank you, Ms. Joyner. You heard earlier, I relayed to the court the agreement that we came to with the state, came to their motion to adjudicate your case, correct?
Yeah.
And informed the court of the terms of that agreement, which include extending you 1 year and eating up your credit time, basically 67 days in jail as a condition of your revision. You heard that as well.
Yes, sir.
Ultimately, the judge expressed his hesitation in approving that agreement. In response, can you tell the court what it is you intend to do differently,
Yes, sir.
or why he should approve the agreement?
Yes, sir. Can I speak?
Yes, please.
I've never been away from my kids this long, and I will do whatever it takes to stay out with my children. My mother is real sick, and if I go to time, she probably will not be there when I get out. I did some classes over in Henderson County, and I plan to continue to AA when I get out. I've learned a lesson, I promise.
Anything else, Mr. Schmidt?
No, sir.
And does the probation department have any opinion on Ms. Joyner and this agreement?
Yes, Your Honor. I spoke with Officer Mewburn, who supervises Ms. Joyner, and she didn't feel like she was a good candidate for probation due to her several positive UAs for alcohol, being kicked out of counseling due to lack of participation and attendance, and that's it.
All right, thank you. Ms. Curry.
And Judge, I just wanted to address it as well. Miss Joyner has absolutely nothing else on her criminal history, not even an arrest. And it seems like such a huge waste to me for her to be convicted of a felony for the rest of her life that will limit her opportunities and everything else because she doesn't stay away from alcohol. I just wanted to offer her one more chance to not have that felony conviction.
Thank you, Ms. Curry. Of course, familiar with Ms. Joyner, I too have tried to intervene in her life in sanctions court. The whole purpose of our sanctions court program is to avoid days like this with people like you that given a chance on probation and given multiple opportunities when you violate it to be in sanctions court, bring you to sanctions court, tell you what's going to happen. And we get here, it's hard for me to approve to put you back on when I told you time after time after time, and you never straightened up. You understand, Ms. Joyner, why it's hard for me to believe anything that you say?
Yes,
I mean,
sir. Yes, sir.
No. You talk, it's my turn, okay? I gave you your talk, I give you your time to talk. Do you understand why it's hard for me to believe anything that you have to say?
I do.
Okay, so it's understandable.
Yes, sir.
And I'm not telling you no, that I'm not gonna do this. I'm just telling you that my gut tells me why. If I put someone on probation and they don't do what I tell them to do, and I bring them in on sanctions court and I say, hey, you're screwing up. I'm trying to keep you out of prison. Trying to keep you out of prison. Trying to keep you out of prison. And you go back and you do it anyway. And you thumb your nose at the court. You thumb your nose at the probation department. And yet you come back in here and you say, give me a third chance, give me a fourth chance, put me on for another year. All I promise this time. You understand how it's difficult for the court, the probation department to get behind you on this.
Yes, sir.
And even the DA saying she wants to try to give me one more chance. Everybody's going out of their way to help you.
Yes, sir.
And this is where you're at today.
Yes, sir.
So I'm gonna tell you the same thing that I told the other probationer. I'm gonna go against what I think the right thing is here. I think the right thing is to reject this, ask for the state to put on a case for me to decide what happens with you. I'm not gonna do that though.
Thank you.
I'm gonna talk to you just a moment. I'm gonna make sure that you're not under duress, all these things, that I'm gonna extend you and I'm gonna take some of this jail time as a condition. And, you know, hopefully I'm not right. And if I'm right, I take no victory in that. So if you really care about your kids like you say you do, you'll actually do something about it. If you don't, you won't. And if you don't, then I'll be here to do my job. You understand?
Yes, sir.
Ms. Joyner, has anybody threatened, forced, or pressured you to extend your probation for an additional 1 year?
No, sir.
Do you agree to the amendment of your conditions to 67 days in the county jail?
Yes, sir.
All right, we'll approve the agreement, or hereby extends the probationary period of Alicia Renee Joyner for an additional 1 year, orders her to do 67 days confinement in the county jails, additional community supervision. Or extends that probation and makes that modification. It's your job to prove me wrong, Ms. Joyner.
Yes, sir. Thank you.
Step over and sign your paperwork. Who's next, Mr. Smith?
Mr. Rossman, Shannon.
Oh.
All right, Mr. Shannon, raise your right hand on the place of the oath. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God.
Yes, sir.
Okay, you are here. All right, I see here that the state has filed a motion to adjudicate. And they allege what appears to be 7 separate violations. And the plea agreement today looks to be, he's gonna plea true to those. The recommendation is to convict him of the offense, assess his punishment at 10 years confinement in prison, suspend that sentence, place him back on probation for 5 years, order him to pay the money he's already been ordered to pay, place him on the mental health caseload as a condition of this. Ms. Burns, before we go any further, is the probation department being consulted on this agreement, supported.
I think he is.
Sorry, I didn't hear you, Judge.
Ms. Burns, I said, has the probation department been consulted on this plea agreement? Do you support the terms, Mr. Shannon?
No, sir.
Would you like to recall and give the probation department an opportunity to review the file? Ms. Burns stated that she's unaware of.
Okay, yes, please, if you don't mind, I would appreciate that. Just a moment, Mr. Shannon, have a seat, I'll come right back up. Just. Anyone else, Mr. Schmidt?
Bryce Carroll.
Bryce Carroll, Mr. Carroll, if you'll step up, sir. All right, CR 21-208, State versus Bryce, Christopher Carroll, motion to adjudicate. Go ahead, Mr. Schmidt.
At this point, I'm not prepared to proceed on Mr. Carroll. We'd ask for additional research.
Okay, are you available on July 25th at all?
Yes, sir.
You are, okay. All right, court will reset Mr. Carroll for an additional hearing on the motion to adjudicate on July 25th at 1:30. Anyone else, Mr. Schmidt?
Brad Rodriguez.
Brad Rodriguez, CR 2269, motion to adjudicate. Go ahead, Mr. Schmidt.
Judge, we'd ask that Mr. Rodriguez be sent for a plea.
On that same 25th date.
Yes, sir.
All right, court will set Mr. Rodriguez to enter plea before the court on the motion to adjudicate on July 25th at 1:30. Who did you say, Mr. Schmidt?
This is Jeremy Ward.
Jeremy Ron Ward, CR 18384, CR 18385, motion to revoke. Go ahead, Mr. Schmidt.
Yes, to set for a plea on that July 25th.
Set for a plea on July 25th.
Yes, sir.
All right, court sets Mr. Ward for plea July 25th at 1:30.
William Petty.
William Petty, CR 16325. Go ahead, Mr.
Judge,
Schmidt.
Mr. Petty, I've spoken with Ms. Curry about the state's motion. By and large, the allegations are monetary. Mr. Petty has had severe health issues while in custody, as well as being on the transplant list. We filed an agreement motion for a PR bond on him, as well as a proposed order. The agreement that we had, or at least Ms. Curry, were to get him out, allow him to tend to his healthcare issues, and then carry him on compliance for financial payment. And hopefully resolve his probation altogether.
Okay, thank you, Mr. Schmidt. So let me repeat, just because it's kind of choppy. You said that your agreement with Ms. Curry is to have an agreed motion to set a personal bond, allow him to get out of custody, tend to his medical issues, and carry him on compliance for financial issues on the motion to revoke that you hope resolves it.
Correct, and we have filed motion for set bond and a signed order for appeal bond. The court should have that.
I
But
do.
yeah,
Yeah,
but
I
in
do.
essence, that's the plan.
Okay, yes, I do have it. I received that on Tuesday. I just holding it under advisement until I can see Mr. Petty for myself. I didn't want to grant him a PR bond on Tuesday and then worry about him being in court on
I understand. Yes, sir.
Is that the state's agreement, Ms. Curry?
It is, Judge.
All right, so let's set Mr. How long on compliance? Do I need to set him every month, Mr. Schmidt?
Yes, please.
All right, court will grant the agreed motion to set personal bond. Court will set Mr. Petty for a compliance hearing on July 25th at 1:30. And I'll get that bond signed today at the conclusion of Mr. Schmidt will submit it to Joe.
Thank you, sir. Start paying that money. When you get out, don't make arrangements to pay that. Better off. Yeah. But you get $9. At lower house, yes. Yeah, just like we're doing right now. Okay.
Who's next, Mr. Schmidt?
So we have recall, Ms. Nash, got Mr. Hogg, we've got Mr. Shannon.
Who about Ryan Keith Collier?
Oh, Judge, I had an announcement on Mr. Collier. He was in here at 1:30. And he wished to absence himself from our hearing. We're not actually gonna. We're not prepared to go forward on a evidentiary hearing. I did speak with Ms. Curry. At this point in time, we're going to withdraw our motion to suppress and ask that he be placed on a docket call. And he's aware of that and he signed a reset. But if you want to call him back in here, put that on the record, we can do that.
No, I trust you, Officer McCord, and you just put it on the record. Was there a reset date given?
You know what, there was, and I think the July 25th date on there because I think that. But it doesn't, I mean, we want to put it on a regular docket then. And I can have him sign a new reset.
Yeah, let's bump him out. That way you have a little more time. I know that you're covered up in July. You want to move him to August 10th? I'm sorry, August 8th?
Yes, sir, that'll be fine.
All right, we'll set him August 8th for docket call. Court will find that Mr. Collier has withdrawn his motion to suppress. In each case. Ms. Burns, have you had an opportunity to talk to the probation officer on Mr. Shannon's case?
I'm still talking with Ms. Griffith at the moment.
That's fine. That's fine. All right, let's Ms. Nash. All right, we're back on the record, CR 22-366, State versus Jamie Marie. Correct me if I'm wrong, but hasn't Ms. Nash already been on ISP on probation?
I don't know that we made it on probation at all the last time, Judge. So I'm not certain. I think that ISP may have been ordered, but I don't recall either. But there was a very short window of Miss Nash's, she had issues quite quickly.
Is that not Dave?
Sorry, I couldn't hear that.
Did you not hear anything? Or what-
No,
what did-
I heard you, Mr. Schmidt, whoever spoke a moment ago, I didn't hear them.
It was a radio, Judge.
What did she say?
It was radio. Somebody,
Oh, it's radio, okay. I'm looking over the judgment. Mr. Schmidt, do you want to call Ms. Nash like you did Ms. Joyner and give her an opportunity to persuade her? All right, Ms. Nash, raise your right hand and official oath. Ms. Nash, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
thank you.
Go ahead.
Miss Nash, you understand that earlier, when we first started your case, the judge asked me to argue on your behalf as to why he should accept this plea agreement and place you back on probation. The agreement was to adjudicate your guilt, so if he accepts this, you understand that you'll be convicted of a third-degree felony. In addition to that, as you've heard, the judge is concerned, the court's concerned that when you were placed on probation first time, you failed to comply pretty quickly. Now, you understand, I made the argument on your behalf that you suffered and struggled with addiction to narcotics, and that became the roadblock in your success every time, correct? Now, I can make an argument on it, but it's not my life, it's your life. And ultimately, it's going to have to comply with the conditions if the judge is going to grant this agreement. Understand that.
Yes, sir.
Now, could you tell the judge in your own words why, given your failure or your lack of success previously, that he should give you another opportunity, place you back on probation? Even though you will be convicted of this, it's a little different, straight probation. But why should he give you another opportunity?
I take care of my 83-year-old uncle. And my family don't take care of God, and part of my drug thing, I'm sober now, and I'm gonna go, if I do get this, I'm gonna go do outpatient rehab and do NA meetings, and I'm gonna do right this time and do the right thing. Stay sober and so I can be out there with my uncle.
And
Ms.
do you,
Nash, I'm sorry, go ahead, Mr. Schmidt.
now, do you understand that the court and everybody in the system deals with individuals all the time who have addiction problems?
Yes, sir.
And when their back's against the wall, everyone says the same thing. They're gonna do
Yes,
better
sir.
this time, right?
Yes, sir.
So what do you think, in your mind, what do you think you have to lose if you don't get it right this time?
My freedom and my uncle, 'cause if I go to prison, he dies, but he'll die. He's only 83, he's got Alzheimer's, so I'm the only one that takes care of him.
And so as far as your addiction and your struggles with that, do you struggle with mental health issues as well?
Sir.
Okay, are there anything, in other words, you understand that the probation department has programs set up, but you have to take advantage of them.
Yes, sir, I will.
And do you have the ability to not only go once a week to report, but to take advantage of the programs that they offer you so that you don't find yourself in this position again?
Yes, I do, do the acceptor programs, and I'll find some like outpatient NA and meetings and outpatient rehab too.
Okay, I'll pass the list.
Ms. Curry, do you have any questions, Ms. Nash?
No, Your Honor.
Ms. Nash, do you understand that you can't take care of someone else if you can't take care of yourself?
Yes, sir.
You ever flown on an airplane?
No, sir.
Well, let me tell you about what happens when you're on an airplane. They give you instructions that if there's any kind of issue while you're in flight, and there's gonna be an oxygen deprivation issue, that oxygen mask, they fall from the ceiling there in the airplane. And they tell you to put yours on first before you try to put it on somebody else. Do you know why that is?
To make sure you're okay.
Yeah, because guess what happens? If you're trying to help somebody else and you don't help yourself, when you have no oxygen, what happens?
I die.
You die, and then you're no help to no one.
Yes,
So
sir.
you've got a drug addiction. Till you address that and you help yourself, you can't take care of anyone. Your uncle, especially if he's got Alzheimer's, you can't take care of anybody. You understand that?
Okay.
So you're telling me that if I give you another chance, you're not gonna screw up. Is that right?
No,
And
sir.
and you're also telling me that if you screw up, you're not gonna come in here and ask me for another chance.
I won't.
You're not gonna do that. That's what you're telling me. You're giving me your word that if you go out and I don't require you to do drug rehab today, because I don't think you can clean up sitting in the county jail. I don't think you can do that. I think it takes a lot more than that. So I don't think you might be clean when you walk out, but that doesn't clean you up. Understand?
Yes,
And so
sir.
if you go out and you immediately relapse, you understand that you're going to prison.
Yes, sir, I do.
And what's the recommendation today, Mr. Schmidt?
4 T's probated balance of financial obligation. After
You said 4 probated for what?
there's 3 on adjudicating guilt. So in other words, we're gonna adjudicate guilt. Assessor punishment of 4 years confinement, suspended for a period of 3 years.
4 probated 3.
Yes, sir.
I'm sorry that audio is so bad over here. Is there any jail time as a condition? I think you told me no earlier, right?
What we know earlier, yes, sir.
So she's gonna get all of her credit if she violates. All right, Ms. Nash, I know better than to ask the probation department how they feel about this. I know how they feel about it. Just like those other people. My gut tells me that you're not gonna make it. Their gut tells them that you're not gonna make it. I'm not telling you that to try to drag you down or discourage you. I'm just telling you the reality of the situation, so that you understand. You show back up, and if I approve this today, you show back up at this jail, wearing that same suit, on this same charge, you already know what the outcome's gonna be. We don't even need to talk about it. It's gonna be 4 years in prison, understand?
Yes, sir.
And I don't think I have any of the paperwork over here.
Probably don't have this one this morning.
Yeah, that's okay with me. All right, Ms. Nash, you appeared before the court on November 8th, 2022. You pled guilty to the 3rd-degree felony offense of possession of a controlled substance. Court heard the evidence, found that there was enough evidence to convict you. The court followed your plea agreement on that day as well, and deferred a finding of guilt, placed you on 4 years community supervision, assessing $1,500 fine. Then the state filed its motion to adjudicate and revoke, and alleged what appears to be 6 separate counts of violations. Mr. Schmidt, does Ms. Nash waive the formal reading of the state's motion to adjudicate?
We do, Judge.
Does she intend to plead true to all 6 counts?
Yes, sir.
All right. Ms. Nash, are you pleased with Mr. Schmidt and his the legal work he's done for you?
Yes, sir.
You understand everything you've read and signed today?
Yes, sir.
How do you plead to counts 1 through 6? Are those counts true or not true?
True.
And are you telling me that those are true because in fact they are true? Not just telling me that so you can get another shot of probation, right?
They are true.
Does anyone threaten, force, or pressure you to plead true to any of these counts?
No, sir.
All right, court will accept the defendant's plea of true at this time. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, your honor.
from the defense?
No further, Judge.
All right, then based on the evidence, the court finds that there has been violation of the court's order, conditions of community supervision. Court will find that Ms. Jamie Marie Nash has violated the terms and conditions of her community supervision. Or hereby adjudicates her guilt on the charge of possession of a controlled substance, really group 1, greater than or equal to 1 gram plus 4 grams in third-degree felony. Court assesses her punishment this day in 4 years confinement. The Texas Department of Criminal Justice the court will suspend that sentence and place her on straight community supervision for a period of 3 years. Order her to pay the balance of her previously imposed financial obligations. Ms. Nash, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Step over to be fingerprinted and talk with probation officers about what's. Ms. Burns, are you ready on Rossman Shannon?
Yes, Your Honor. I talked to Ms. Griffith and she was fine with the offer.
All right, step on up, Mr. Shannon. All right, we're back on the record. Mr. Shannon, I think I placed you under oath earlier, didn't I?
Yes, sir.
All right. Mr. Shannon, did you hear what I asked Ms. Burns to find out? I asked her to talk to your probation officer to see if they're supportive of this or not.
Yes, sir.
And you heard what she said. What'd she say?
We're fine.
What does that mean? What does that mean to you?
That means I have another chance to.
Yeah, you're a smart man. It means you have another chance. Your probation officer hasn't written you off yet. There's plenty of other people behind you that the probation officer have already written off. They feel like they don't have a chance, that they're not serious and they can't comply. And that's why I'm asking them today, because they've spent the most time with you all. They understand you better than I do. And their insight is helpful to me. And so you should appreciate your probation officer saying, I'm fine with this recommendation. And the recommendation is that you're going to be true to the state's motion to adjudicate. You're going to be convicted of assault, family or household member by being breath or circulation. Your punishment is going to be assessed 10 years confinement in prison. We're going to suspend that and be placed on 5 years community supervision. You're going to pay the fines and court costs and reimbursement fees that you've already had. And you're going to be placed on the mental health caseload as a condition of your community supervision. That's what you're asking the court to do today. Is that correct?
Yes, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with the work that he's done for you and the offer he's gotten you today?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Mr. Shannon to be competent, that he understands his plea and that he's entering into it intentionally, knowingly, and voluntarily?
Yes, sir. I do believe that he is legally competent and that he's entering into the plea knowingly and voluntarily.
All right, Mr. Shannon, and Mr. Schmidt, does Mr. Shannon waive the reading of the motion to
Yeah, you're, yes, we do.
All right, then, Mr. Shannon, I would ask you at this time, how do you plead to counts 1 through 7 as alleged by the states, or those by the states, those counts true or not true?
True.
Are you telling me that all 7 counts are true because in fact, those things that they said about you are true?
Yes, sir.
You're not just saying that so you can have another chance at probation, right?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
Defendant's waiver of rights, plea of truth admitted by the state's evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No objection.
All right, based on the defendant's judicial confession today, the court finds, and in the evidence submitted, the court finds that Mr. Rossman, Renee, Shannon has violated the terms and conditions of his community supervision. Court follows the plea agreement today. The court adjudicates his guilt, convicts him of assault of a family or household member by impeding breath or circulation. The court assesses his punishment today at 10 years confinement in prison, suspends that sentence, places him on community supervision for 5 years, orders him to pay the balance of his financial obligations. orders him to be placed on the mental health caseload as a condition of his community supervision. Mr. Shannon, I would tell you the same thing that I told Ms. Nash earlier. You said in there and you've heard it. You understand that if you don't take this serious and you screw up on community supervision, you violate, and you end up back where you are today, there's going to be a much different outcome for you than the opportunity that's before you.
Yes, sir.
All right. All right, Mr. Shannon, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Please step over to be fingerprinted. All right, Mr. Schmidt, other than Mr. Hogg, who do you have left?
I think that's it, Judge.
We're not gonna forget you, Mr. Ozuna. We won't forget you. I'm not sure the state's aware, but we had Lynn Allen Smith on the docket today with Mr. Bauman. He filed a motion for continuance.
Yes,
Court granted that, I reset that for July 25th. Hey, Mr. Schmidt,
Yes, sir.
what are you about to do?
I was talking to Mr. Hall.
Okay, talk to Mr. Hogg and then will you step out and give me a call on your cell phone before we do? Thanks.
Yes.
You can go and talk to him first though, okay?
Okay.
You think Jonathan Walls, I mean, up there,
Say again?
Jonathan, I think he's in there.
He probably is. He's probably-
Your Honor, let me go take Mr. Manning and then I'll be back.
Okay. All right, for the record. Earlier today, the court called three individuals on the morning docket. Court called cause number CR 21168. State versus Joshua Ray Hand. Mr. Hand was not present in court, nor did he make himself available at any time of day. Court also called cause number CR 2158. State of Texas versus Randy B. Dobbins. Mr. Dobbins was not present at the time his case was called, nor did he show at any other point during the court's docket. Court also called cause number CR 2154, State versus Michael Shane Covey. Mr. Covey also did not appear at the time that his name was called, nor in any other time the court is going to order judgment by side Felix habeas for Michael Shane Covey and Randy Dobbins. Court is going to grant 1719 surrender of principal filed by Second Chance Bail Bonds in Mr. Hand's case. So nice eyes and habeas for Michael Covey and Randy Dobbins.
Your Honor.
Yes, ma'am.
Okay, Mr. Manning is working on the plea papers on Mr. Lyons. He said he likes about 15 minutes.
All right, tell him he's got 7.
And Ms.
All right,
Burns,
Mr. Hogg, step on. Ms. Burns says what?
she's on her way with some police. For you.
Oh, okay, I'm excited about that. All right, Mr. Hogg, we're gonna start over. Raise your right hand. I'm gonna place you under oath. Mr. Hogg, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You put your hand down. This is cause number CR 21-125, State versus Matthew Tom Hogg. Mr. Schmidt, does Mr. Hogg intend to waive the formal reading of the state's motion to revoke today and plead true to all, what appears to be 10 counts alleged in the state's motion?
Yes, sir.
All right. And, do you believe that he is competent today and understands his plea and that he's, entering it into it intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Hogg, are you, pleased with Mr. Schmidt as your attorney and the work that he's done for you?
Yes.
Okay, do you have any questions about any of the paperwork that you've read and signed today? Do you understand everything? What's going on?
On the fines and court costs, like whenever I get out on parole, like where do I go, or to pay it, you know what I'm saying?
Yeah, no, that's a good question. Whenever you get out on parole or you get released from TDC, then you just come back to the courthouse and you tell them that you're here to pay your fines and court costs, and they will send you to the right office where you can meet with somebody and they can set up a payment plan and you can pay those things out.
Okay.
Okay. It's a good question. That's a good question. All right, it looks to me that Mr. Hogg, upon a plea of truth, the state's recommending that his community supervision be revoked, that he be sentenced to 3 years confinement in TDC, that he pay the balance of his financial obligations, and he's going to get 164 days credit towards his sentence for the time that he's already been in jail. Is that correct, Mr. Schmidt?
Yes, sir.
All right, Mr. Hogg, then let me ask you, how do you plead to counts 1 through 10? Are those counts true or not true?
They were true.
Okay, and has anybody threatened you, forced you, or made you feel like you had to plead true to any of those counts?
No.
All right, then the court will accept the defendant's plea of truth to each of the 10 counts. Mr. Schmidt, any objection to the defendant's evidence? I'm sorry, to the state's evidence, which is the defendant's waiver of rights plea of truth?
No objection.
All right, then that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? No, Your Honor. From the defense?
No, sir.
All right, based on the evidence presented today in Mr. Hogg's judicial confession, the court finds that Mr. Hogg has violated the terms and conditions of his community supervision. Court revokes his community supervision, follows the plea agreement, and sets his punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 164 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Hogg, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted, and then whenever you do get out, come see us at the courthouse and we'll make arrangements for your payments.
I believe that's all I have. Judge, may I be excused?
Yes, sir, you go home.
Thank you. Yeah, ma'am. I believe in it. So when do I get a copy of that? I'll send them over in there. All right. Okay. Appreciate it. Good.
Few more minutes.
Okay, no problem. Tell him he's got 2.
Your Honor,
Yes, ma'am.
we're ready to rock and roll.
All right, give us a few minutes.
No, he's still there. Yes, sir.
All right, Ms. Abraham, I'm ready.
All right,
Who do we have first?
Judge, Mr. Richard Ozuna.
Mr. Ozuna, if you'll step up, please. It's cause number CR 22-385, CR 22-232, State versus Richard Ozuna. Go ahead, Mr.
Judge, we are kind of doing a two-part announcement here. First part is, I have received the video evidence back from the examined forensic expert, and have begun my review of it. And at this point in time, it is my assessment that the evidence that we were hoping was going to be there was not there due to some unknown reason at this point in time. I'm going to visit with the experts one more time to discuss any possibility of residual, but at this time we have the video and it has answered the questions we need at this point. However, in the course of my conversation with Ms. Curry, I was made aware of additional discovery that was not previously disclosed that affects one of Mr. Ozuna's other cases. And I have not had an opportunity to go over that with my client. I think that's going to focus our negotiations. I've additionally received a plea offer from Ms. Curry, and I would like some time to discuss that with my client. If we can be set for pre-trial for me to review this new discovery and discuss it with my client tomorrow, then I think we should be ready for announcement on whether there's contested matters in both of these cases.
You be set at July 25th or August 10th.
Judge, due to the length of time that Mr. Ozuna has been in this jail, I would request the earlier date. My understanding is that Ms. Curry is also going to be turning over the video copy that they have, but I think it shouldn't take long to compare those to what footage I have.
All right, court will set Mr. Ozuna for additional pretrial and update on video evidence on July 25th.
And Judge, could if Mr. Manning can hear me, I'd like to clarify just a couple of things.
I do turn on that other right there too next to you. If you'll turn that one on, it'll also help you. Yeah, go ahead.
Mr. Manning is correct. I believe we finally have the issue of the DVR from his client's house settled. In the course of this case, getting transferred back to me after Ms. Heisel left, and in the course of my meetings with Mr. Manning and reading some of the written documentation, it became apparent that the written documentation was referencing items that I did not have. So I reached out to Ranger Adcock. He is in Waco this week. He tells me that yes, he has those scans and measurements, and that he will deliver them to me next week when he gets back to Waco.
Did you hear that, Mr. Manning?
I did, Judge, and that accurately reflects my conversation with Ms. Curry. The biggest thing was that there was a discovery that was in possession of the state that the DA's office did have that for some reason had not been opened up to me. And so that's what we're going to begin discussing tomorrow. I believe that based on our discussions, the scans and other data, while voluminous, will not be as important as the new reports that they're going to be that have been turned over.
Okay. All right. We'll see everyone back on July 25th for Mr. Ozuna. All right, you ready, Mr. Lyons?
Yes, Judge.
KTM Alliance, CR 23-14, CR 22-152, CR 22-276. Mr. Lyons, sir, you raise your right hand. I'll place your oath. Mr. Lyons, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, lower your hand. Mr. Lyons, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. You pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you have any questions about any of the paperwork that you signed today?
No, sir.
You understand everything that you sign, you understand everything that's going on in your plea agreement, is that correct?
Yes, sir.
Mr. Manning, do you believe Mr. Lyons to be competent?
I do, Judge. And
You explained to him his rights. You explained to him his rights as they pertain to this case, and you believe he's entering into this intentionally, knowingly, and voluntarily.
I have, Judge, and we had a lengthy discussion about those rights today.
All right, let me go over what appears to be the plea agreement. Correct me if I'm wrong. In CR 23-14, Mr. Lyons is charged with unlawful possession of firearm by a felon. That's a third-degree felony offense that usually carries a range of punishment of not less than 2 years in prison or more than 10 years in prison. The state of, I guess, originally filed an enhancement paragraph, which would, if found to be true, would increase that range of punishment to that of a second-degree felony, which carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. It appeared Mr. Lyons, in part of this plea agreement, would plead guilty to that offense, would be pleading true to the enhancement paragraph, would be assessed a punishment under a repeat felony offender statute, in that the punishment would be 5 years confinement in the Texas Department of Justice, a $1,000 fine. State is dismissing under section 1245 numerous cases as outlined in the judgment, and there was an agreement on the weapon forfeiture in this case, which deals with a Ruger, actually 2 Rugers. Is that your understanding, Mr. Manning?
Yes, Judge, and just so the record is clear, there are 14 cases being resolved. The 1 case being pled to, and then 13 cases being dismissed under 1245. There was some confusion, and part of what we were trying to confirm earlier was Mr. Lyons was concerned about a 15th case, and for the record purposes, that 15th case was actually the case that was filed as a duplicate to this indicted case. It was filed by information, and when the DA's office took that to the grand jury to get it indicted, they dismissed the underlying cause number 23-0002, and that order was signed on May 30th of 2023. That resolves, my understanding, all of Mr. Lyons' business here in Van Zandt County, and that was confirmed with the DA's office.
All right, thank you, Mr. Manning. In addition, Mr. Lyons would get 312 days credit towards the sentence for time he's already been in jail. In addition, he'd have fines, court costs, and reimbursement fees. Is that your understanding as well, Mr. Lyons?
Yes, sir.
You're asking the court to approve that specific plea agreement today, is that correct?
Yes, sir.
All right, Mr. Lyons, I'm gonna ask you this time, how do you plead to unlawful possession of firearm by a felon?
Guilty, sir.
Mr. Lyons, how do you plead to the enhancement paragraph alleged in the state's indictment? Is that enhancement paragraph true or not true?
It is true, sir.
All right, now are you pleading guilty to the offense and true to the enhancement? Because you are guilty of committing the offense and the enhancement allegation is true. You're only telling me those things because in fact they are actually true. You're not saying that just to get a plea agreement, is that correct?
Yes, sir, they are true.
All right. Court will accept the defendant's plea of guilt at this time and his plea of true to the state's enhancement paragraph. Mr. Manning, any objection to the state's evidence supporting the plea?
Judge, I would just clarify that my client is only being guilty to the parts of the state's exhibit 1 and pleading and acknowledging the parts that apply to the unlawful possession of the firearm by the felon. He was not waiving any defenses or rights to any other cases that may be included or discussed in that stipulation of evidence. But those other cases are what led to the eventual search warrant and search of his home, which located the firearm.
All right, thank you, Mr. Manning. Anything further from the state?
No, Your Honor.
All right, the court's going to, anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
The court's going to review the evidence briefly. And J. Lyons, unlawful possession of firearm by felon. Court will follow the plea agreement in this case. Court hereby convicts Mr. Lyons of that offense, finds that the enhancement paragraph in the indictment is true, finds that the degree of the offense is a third-degree felony increased to repeat felony offender, that of a range of punishment of 2 to 20. Court assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $1,000 fine. Court dismisses under section 1245 all DA cause numbers listed in the judgment. In addition, the court will forbid the weapons specifically identified on page 3 of the judgment to revert firearms. Court assesses a $1,000 fine, $290 court costs, $90 in reimbursement fees, and awards Mr. Lyons 312 days credit towards this sentence for the time that he has spent in jail on this case. Mr. Lyons, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. When you get out on TDC, please report to the Massey County Courthouse so you can make arrangements for a payment plan to discharge your fines, court costs, reimbursements.
Judge, you were breaking up there.
Good report to the sheriff.
There was some, I guess, the computer was freezing. On the taking into consideration that the court did say they were going to take into consideration both CR 22-152 as well as CR 22-276. Is that correct?
That is correct. Court said it's taken into consideration under section 1245, all cause numbers and DA numbers as reflected in the judgment. I'm just not going to read all those.
Yes, Judge.
All right, and then you heard me say, Mr. Lyons, report to the courthouse after you get out of TDC so you can pay your fines and fees, correct?
Yes, Judge.
Okay, all right, please step over with the deputy to be fingerprinted. Handed to the custody of the sheriff to carry out the terms and conditions of the sentence. Thank you, Mr. Manning.
Thank you, Judge. May I be excused?
Yes, sir, I'm going to award you comp time today.
Well, Judge, I'll be using that next week.
I'll call your wife and tell her you got some comp time today.
All right, we will see you, or I'll see you in a minute.
Good luck, but hurry.
I'm hurrying.
All right.